So hello and welcome to our webinar on libraries, copyright and AI for science and research, the first in a series of 4 EIFL webinars on copyright and libraries. My name is Teresa Hackett. I manage EIFL's Copyright and Libraries programme. So I'll go through a couple of housekeeping items before introducing our 2 speakers who you can see on the screen. The webinar is scheduled for 1 hour. It's being recorded, and we'll share the recordings and the materials afterwards. There'll be an opportunity to ask questions during the webinar. Please use the Q&A function, which is down on the bottom of your screen. And my colleague Edwaldus will keep an eye on the Q&A as well as on the chat. So we wanted to do a webinar on AI because we had requests from librarians in EIFL partner countries, and also because AI plays a critical role in important areas such as science, drug discovery, and climate change. But restrictive copyright laws and restrictive licenses are a barrier. And while libraries have been advocating for copyright laws that enable the use of digital research tools for the last number of years. In the EU and Singapore, for example, there are new provisions on text and data mining. AI is a fast-moving thing. The introduction of generative AI in 2022, only late 2022, only 18 months ago, introduced a host of new issues that policymakers and regulators are struggling to keep up with. Issues like bias, transparency, misinformation, and of course, copyright. Generative AI also led to the entry of new players into the debates, such as the entertainment industry, whose interests are different to those of science, research, and libraries. So today, our focus is on AI for research and innovation. What are the copyright issues? What are the policy issues for libraries? And what's happening in copyright laws and in the courts that are deciding on the issues. So we have 2 expert speakers. Ben White is a researcher at Bournemouth University's Centre for Intellectual Property and Management and co-founder of Knowledge Rights 21. Before that, he was head of IP at the British Library, chair of LIBER and CENIL legal working groups, and he started his career in the publishing industry. Ben has been an expert witness on copyright and digital issues at the European and UK parliaments. And in 2021, he was awarded a Copyright Lifetime Achievement Award by the Chartered Institute of Library and Information Professionals in the UK. Our second speaker is Jonathan Band. Jonathan is a lawyer based in Washington, DC, who specializes in the application of copyright law to digital technologies. He has deep, substantive knowledge of copyright laws, both in the US and in many countries around the world, including EIFL partner countries, as well as copyright issues specifically related to libraries like digitization and e-lending. And in 2017, Jonathan received a Lifetime Achievement Award from the American Library Association for legislative advocacy and legal counsel. So to kick off, we're going to hand over to Ben, who will talk about libraries, copyright and AI, the principles and the policy issues. So Ben, handing over to you. Thank you.
Does that fill the whole screen?
Yep, we can see. Okay,
so welcome everyone. So just very quickly, just want to introduce Knowledge Rights 21, KR21. We are an Arcadia funded project working under IFLA, and on our management committee we have LIBER and Spark Europe, which will mean something to those of you in the library world. And we work across Europe. We have a policy lead in Brussels focused on the European Union, and then we have national coordinators in the countries outlined in the screen. So getting to the sort of substantive point, I think what I'm going to do is an overview. I'm not going to get deep into copyright. That's Jonathan's going to do that. I'm going to just pose some questions. So essentially, artificial intelligence is simply software that makes either predictions or classifications. It's not intelligent, it is just software. It doesn't have autonomy and it doesn't have independence, and therefore it is certainly not intelligent. It is the result of data scientists working on software with large data sets and on increasingly sort of speedy and hefty hardware. And there are many different sorts of AI. I mean, we hear about neural networks. Actually, they are not even in the top 3 most used AI algorithms. So there's a vast different array of different software models that can be used. And in fact, not all models train on data. They all analyze data, but not all of them are trained on data. It's a jargon-tastic environment, and Teresa's already spoken about generative AI, which I haven't put down here. Generative AI has different meanings depending on who you are. If you are a data scientist, generative AI is a type of software model which makes a prediction. I would say in natural parlance, in natural language, generative AI has come to mean something slightly different, which is models which train on data to produce some form of similar output to the input. So if you input photographs, it'll output photographs. If you input text, it'll output text. And generally, I think, I'm not going to get into the different nuances, but generally all these terms can be used pretty interchangeably at a certain level. From a technical perspective, they have slightly different nuances, but we don't really have time for that. So I might use all these terms, but generally they're rather interchangeable. AI is everywhere. It's in our spam filters. It was in my drive back from the beach this morning when I did a routing. Teresa's already spoken about new antibiotics have been discovered using artificial intelligence and machine learning. Obviously, I'm sure everyone's heard of ChatGPT. Internet search is a form of machine learning to produce the search algorithms that the search engines have. So it's basically everywhere. As I said already, data is crucial to this field of software. All models will analyze data, but only some models, the so-called eager learners will train on data. So data is fundamental. As I said, the software is usually derived from open source AI toolkits, software libraries. It requires they require training. The eager learners require training. Those that train on data have to be trained. And essentially what happens there is software is used to understand the best settings of the software. So the software doesn't overfit to the data, so it isn't too close to the data, but it still is able to make predictions and classifications from the data it trains on. So those are called, the software settings are called the hyperparameters. So essentially the data scientist playing around with hyperparameters to produce the best results. And as the examples that I gave on the outputs are multiple, it can be the movement of a robot. It could be a percentage probability. It can be a route, it could be a picture, it could be a sentence. In the case of generative AI, it can be a new antibiotic. Software can do lots of things. So really it's as broad as your imagination. And as with other information technologies, which have a tendency to create monopolies, natural monopolies. We have in search is dominated by Google, logistics and deliveries, as we know, dominated by Amazon. So information technologies have a propensity to create monopolies. And according to Joseph Stiglitz, Nobel Prize-winning economist, there is absolutely nothing to indicate that AI is going to be any different at all. So as with the super platforms, we kind of expect this few large companies to dominate large parts of the AI market. And why is copyright relevant? It's not the first thing that you think about, or when you talk about AI, lots of people start talking about ethics. Well, copyright is deeply relevant because, as I pointed out earlier, either data is analyzed by software models or data is used to train those models. So unless the data that you're using is not subject to copyright law, or in Europe, sui generis database rights, i.e. it's in the public domain, then copyright is not relevant. But that's, most software trains on material that is going to be in copyright. So the question becomes, is it your organization's copyright, or is it the organization, is it a third party's copyright or related rights that we're talking about? The internet is, I'm sure, is the most used source of data for AI. And of course, that is awash with intellectual property rights, particularly copyright. And copyright is important because, we live in a computerized world, a digitalized world where computers copy. My phone copies the internet. Watching this, copies are being made constantly on servers, on your computer, etc., etc. So copyright's important because it essentially regulates how technology markets can function, whether they can function as optimally or whether copyright slows innovation and experimentation down. Jonathan's going to sort of, I think, talk about different models. So for just very, very quickly, certain countries, fair use countries like America, Singapore, Taiwan, South Korea, Sri Lanka, Nigeria have more flexible copyright regimes, which I think, we can say certainly do allow machine learning. And in Europe, we have more restrictive copyright approach to copyright, where essentially it's not principle based. It's basically, if it's not on the shopping list, you can't do it. And in the UK in 2014, and then at the EU level in 2019, specific, very detailed exceptions to copyright law were created to allow machine learning. So there we go. That's what I've just explained in one slide, but Jonathan is going to talk to this. So I don't really need to. On the left-hand side, I guess what I would say, the negative, from my perspective, around Europe is that it's rigid and prescriptive approach to machine learning. On the positive side, the EU directive does not allow contract override of the machine learning exceptions, and also it doesn't allow technical protection measures. Digital locks, technical DRMs, call them what you want, to prevent organizations doing machine learning, in theory at least. So the exceptions between 2014 and 19 were introduced in Europe. We saw in the United States a number of different cases, which I'm sure Jonathan will talk about, which certainly indicate that certain forms of machine learning fall under fair use and are therefore permissible. Japan introduced a very good exception, flexible exception in 2018. And then I think at that point, there was opposition from the STM industry, but the entertainment industries, i.e. the other industries, not the publishing industries, were not so engaged, I think, in the development of the legislation. And as Teresa's, I think, implied really because of generative AI. This is now changed. So now we have the entertainment industries, the publishing industries really lobbying against libraries and all organizations undertaking machine learning. So here we've got this example from the UK Publishers Association, nonsense saying that an updated exception that the UK government was going to introduce because of lobbying it stopped would mean that everyone can use all publishing stuff for free. Which is not exactly correct. I mean, just looking at libraries and one section of the publishing industry, looking at scientific, technical, medical publishing, libraries spend about $10 billion a year on STM content. And yet we have the head of the UK Publishers Association in Parliament claiming that these exceptions will allow people to use stuff for free. I mean, yeah, so that's the level of the debate that we currently have. I guess one sort of policy, from my perspective, I think interesting question is, search, as I mentioned earlier on, is essentially the big search engines tweaking their software to improve search based on the data that they analyze. We know that it took Bing something like 10 years to reach profitability and still nowhere near the popularity of Google. So sort of data matters in this world. And I guess I feel we're rather there's a lot of tunnel vision talking about AI, whereas actually that's what internet search is and therefore we've found ways of accommodating in the law, through case law, through statute, search engines. And I'm kind of concerned that new laws or court rulings which may come in the future may pose questions about the functioning of the internet. So again, just very quickly, some of the issues that have arisen from the prescriptive approach that we have in Europe is with the exception of a few countries like Germany, which allow the sharing of data amongst collaborative partners for non-commercial research purposes. Generally, the exceptions are silent on sharing. So how can you share the How can you share the training data? How can you share the results? So that's, I think, a big problem with the European approach about the extent to which you can share data. What's the point of doing machine learning if you can't share the outputs or your findings? The EU approach hasn't done a very good job. In fact, it's entirely silent on cross-border machine learning. So we have a single European research area, but the legislation forgot to implement a cross-border effect. We see quite a lot from the publishing industry. There's a blog which I have a link at the end where the publishers are saying, but the legislation only allows text and data mining. It doesn't allow other forms of research, which I think, again, is frankly nonsense. The legislation talks about data analytics in the case of the UK, or in the case of the directive, it says soft text and data mining is defined as paraphrasing software which allow classification, prediction, and other activities. So it isn't just limited to text and data mining. And if there was any doubt, the EU AI Act, which is about large language models, requires that large language model creators are compliant with the directive. So if it was only text and data mining, it wasn't other forms of sort of generative AI, then there wouldn't be a requirement to comply, I would argue, with the Copyright and Digital Single Market Directive. And European research exceptions only allow non-commercial research. So that's a big problem for public-private partnerships. And Article 4 of the CDM directive allows rights holders to opt out. So basically saying, no, you can't do machine learning on my material, which we will talk about in a minute. I guess Jonathan will talk a little bit more about this just very, very quickly. Fair use countries contract override is arguably permitted, so that so essentially through license and terms and conditions, it might be possible to override fair use or other flexibilities in copyright law. And again, different countries have different approaches to circumvention of technical protection measures. So I think in that respect, the European approach is good. I think more broadly, sort of heading really towards the issues, it feels to me that the mass media, the newspapers are full of sort of doom and gloom stories, which I think makes, at a policy level, having a positive approach to AI more difficult. You know, as Teresa said at the beginning, AI is used for agriculture, science, medicine, weather. It has many, many, many beneficial uses, and yet the overall narrative feels quite negative. So I think we've gone from the sort of peak of optimism to the sort of the trough of despondency very, very quickly. As I said, Article 4 of the CDSM directive allows rights holders to opt out. The three things that make good AI are velocity, the speed of your processors, volume of data, lots of data, and veracity of data, the right kind of data for the question that you want to answer. So, and as we know, bias is an issue with AI, and yet Europe wants safe AI, but at the same time is limiting the inputs to the AI, which is going to affect the volume and the veracity of data. So Europe seems to want safe AI, but Knowledge Rights 21 would argue is actually promoting bias. And I think that is a topic which needs to be surfaced much, much more strongly, given the pressure to sort of roll back on the exceptions that we already have, which, you know, as I said, Article 4 actually promotes bias through opt-outs. Not a problem, perhaps, if you're making generative an AI model for music, but it is a huge problem in the scientific area. So this is a debate that I think we need to have a lot more. I've already talked about this. Is AI really any different from internet search? And therefore, rulings and decisions, I think, going forward could have a detrimental impact on the internet. Libraries are being approached by particularly large AI model producing companies. And in a sense, again, there's nothing new here. You know, if you're approached for access, presumably to your out of copyright collections, then you need to think about, from a library's perspective, what it is that you want in return for giving that data. And, you know, public-private partnerships is something that have been around for many, many, many years between the larger research libraries and private actors. So again, I think, you know, I would argue here there's nothing new. You know, you need to be on the ball. You need to think about what it is you want. STM publishers, there's a blog at the end, so, as I said, are trying to say you can only use TDM, STM content for TDM purposes, not wider AI purposes. So in this sense, they're sort of contracting around the exceptions that we have in Europe. which I think is an important development. Scopus, according to Scopus, 38% of articles were gold open access, so they've been paid by taxpayers to be in the public domain. And yet the databases and the terms and conditions are restricting access to a lot of material, which I am sure will, in fact, should be, because it's being paid for by the taxpayer, in the public domain. So publishers are trying to restrict what universities and others can do via contract. And that certainly abuts against the fact that actually growing amounts within that database should be under a CC BY license or a CC BY NC license, because it's been paid for by the taxpayers, which I think, with a machine learning hat on, really drives you to, us needing to really start to invest in public infrastructures. So winding up, nearly done. There's lots going on here. I think, to me, it really underlines why it's important for senior library directors and leaders within the sector to really positively engage in copyright, because, as I've said, we now have non-contract override of machine learning, for example. So the exception is the core. So depending on how good or bad that exception is, the publishers are able to expand or restrict accordingly what you can and can't do. So I hope you understand what I'm saying from the concentric circle image there. So how copyright is defined and how licenses are defined is the fundamental of what a library does in the digital world. It's about access to the collections for your users. And therefore, my organization thinks it's very important that senior leaders invest in copyright licensing skills and also policy and government affairs work, because it's the lifeblood of what libraries do. Very, very quickly, I've talked about bias. That Article 4 in Europe, I think, is promoting bias, which is something we need to talk about a lot more. I also sense in Europe that there is going back to this, AI is an information technology creating natural monopolies. There seems to be a sense that, there are good actors, small European companies, and bad actors, larger US multinationals. A couple of things I've seen recently sort of talk to that, but at the end of the day, we are publicly funded, and it's up to it's not up to libraries, I would argue, to decide who is good and who is bad. It's really up to libraries to think about what it is that they want from relationships with third parties, whether they're a local SME or whether they're a large player.
Ben, can I just interrupt you for 1 second? I think the slide deck you're using is not necessarily the last version. So Edwald is going to step in and he's going to show those last 2 slides that I think you're expecting.
Apologies.
Yeah, that's it. Perfect. All right. So we'll just go back 1 slide, Edward, to 23, and we'll pick up from where we were. Yeah, that's right. So we have an addition here of the bullet point transparency and monitoring, Ben. I don't know if you wanted to talk about that, and then the principles.
There should be the slide which links to this, but essentially KR21 has issued document principles on artificial intelligence, science and research. I've covered quite a few of these. So already, it's important that we don't just think about the music industry, that AI is vital for science. Volume and veracity of data matters, and therefore we need to encourage input. We would argue that it's the outputs that you need to regulate where issues arise. It isn't at the input stage. We need transparency, of course, but certainly in Europe, we see some developments with the EU AI office push towards transparency. We would argue that is being pushed by publishers and others because they want to find out what it is universities are doing with their content. And therefore, it's very important that any thoughts about transparency, which is very important, don't actually tip over into monitoring, and that we sort of think about the balance of transparency with freedom of expression, freedom of information, freedom of science, and essentially, create an environment which encourages universities to undertake machine learning. Next slide. I think there's the next slide should just be links. So if you go to if you're interested in the work that we've been doing in this area, there's quite a lot which you can see in the bullet points. If you look at the URL at the bottom of that long read will be other links off to other documentations that we've produced. And I think that's it.
Yes, that's it. Thank you. Thank you very much, Ben. And we'll be sending out the slides to everyone afterwards, so you'll have all that information. And then we can also put into the chat the links to some of the documents that Ben was referring to. So thank you very much, Ben. So with that, we're now going to hand over to our second speaker, Jonathan, who will briefly give us an update on AI provisions in copyright laws and litigation. And please do, if you have questions, put your questions into the Q&A. I see we have a question in there already, and we'll take the questions then after Jonathan's presentation. So Jonathan, it's over to you, and Edvaldus, you're going to share these slides. Thank you.
Thank you very much, Teresa, and thank you all for being here. As we wait for the slides to appear, here we go. Yeah, next slide, please. What I'll be doing is sort of digging in deeper in various topics that Ben raised. And so just to make it clear, I mean, we're going to really focus on the copyright issues related to ingestion, sort of the ingesting all the data that's necessary for training these generative AI models. There are other copyright issues. To what extent are the outputs infringing? That ultimately is an issue that's governed by sort of general existing copyright principles. Also, to what extent is the output copyrightable? To what extent, once you create something with an AI, to what extent can you receive a copyright? That's a different issue. We're not going to be covering that. So we're going to be covering sort of what has been the most controversial issue so far, which is, does the act of ingestion infringe copyright? So as Brent explained, training AI requires the ingestion of millions, if not billions, of works. The software analyzes these works to discover patterns, relationships, and trends, and those are what's reflected in the model. And what I'll argue is that most countries that have examined this issue so far have determined that ingestion does not infringe. Now, I'm sure a lot of people would disagree with that analysis, but that's, I'll show you why, at least I think that is the case. Okay, next slide, please. So starting with the European Union, and again, Ben covered a lot of this, but I'm just going over like just one level more in detail. So you have the EU Copyright and the Digital Single Market Directive, and that was finally adopted in 2019. It applies in 27 EU member states. By now, they were all supposed to have implemented it. Not all have, but they're in process. And it's important to remember that there's two different articles here are relevant. One article, Article 3, focuses on non-commercial scientific research, and Article 4 is basically everything else. So Article 4 is of greater interest to the press and, to the companies that are engaged in this activity. But Article 3 is of more interest perhaps to people on this Zoom and to people engaged in scientific research. And so Article 3 happily is much broader than Article 4. The bodies in the EU recognize that it makes sense to treat commercial entities different from people engaged in non-commercial scientific research. And so again, what Article 3 does is it basically allows all the copying necessary for text and data mining purposes for non-commercial scientific research of when you're dealing with lawfully accessed works. And one could really analyze each parts of this statement of Article 3, which is actually very simple, but each part of it could be require more detailed analysis as to exactly what that means. But the biggest question with Article 3, and this is sort of been alluded to, is like, what does text and data mining mean? And is text and data mining the same thing as training AI, and especially training generative AI? I mean, to what extent do these terms overlap? And so here it's really important, because when you hear text and data mining, that doesn't really sound like training AI, right? If you just go on the basis of text and data mining, I mean, those words. But then you have to look at how it's defined in the directive, and it's defined as any automated analytical technique aimed at analyzing text and data in digital form in order to generate information, which includes, but is not limited to, patterns, trends, and correlations. So once the term text and data mining is defined, you say, oh, okay, that sure sounds like training AI. Again, the phrase text and data mining on its face, it's not intuitively obvious that it includes training, but certainly when you look at the whole definition, it does appear to be training in AI. I don't think there's going to be a lot of controversy again so far, at least with the Article 3, because again, that's going to be for non-commercial scientific research purposes. And so that's not where the money is, right? Where the money is with Article 4. That's what, because that's the exception that Microsoft and Google and everyone else, all the commercial entities that are engaged in AI activities. Now they're allowed, they do have an exception for all this copying for text and data mining purposes, text and data mining, but for other purposes, i.e. not non-commercial scientific research, but for other things. And so, but again, that's using the same term, text and data mining. And so presumably a court, when it's litigated, is not going to interpret it, text and data mining, more narrowly in Article 3 than more narrowly in Article 4 than in Article 3, because it's the same term defined in the same place in the directive. But here, the important part with Article 4 is it is subject to an opt-out, so that a website operator can, in theory, say, I do not want my work included in your training database. So you can't copy my work for training purposes. But the opt-out has to be machine readable. And it seems pretty clear that what they were thinking of, that the authors of the directive, the legislative bodies in the EU, when they were working on this, what they had in mind is something like the robot.txt exclusion header, so that a software such as a bot, which is crawling the internet looking for content to suck up, if it gets to a website that has a header saying, do not crawl me, it would know not to crawl. Okay, that's what they're thinking of. Well, what's really important there is that the large companies that even, you know, with or without the opt-out, I mean, they're, you know, most companies that are crawling the web, they respect these bot exclusion headers. Now, until recently, one of these headers, you basically, if you said, I don't want my website crawled, you couldn't have it, you would prevent it being crawled for any purpose, meaning search as well as AI training. And that was a problem for a publisher, because that would mean, you know, a website publisher, that would mean that if they were to opt out, they would be invisible, right? They would not be in Google search or in Bing. They would, because they wouldn't be, their website would not be crawled for any purpose whatsoever. And the website publishers felt that that was a very unfair choice, right? To say you either have to be, you're either visible on the internet, but if you're visible on the internet, that means that your work is being included for training purposes, or you could not be trained. Your work would not be included for training purposes, but then you'd be invisible. Your website would not be included in a search index. But now Google and Microsoft have tweaked their exclusion headers, and so now you can say, I want to be crawled for search purposes, but not for training purposes. And that, as a practical matter, should make a big difference. Finally, with respect to contract override, the point that Ben was making, Article 3 says you cannot prevent, a contract term cannot override Article 3. So you can't sort of contract out of Article 3, but you can contract out of Article 4. Okay, again, sort of distinguishing between the two and giving commercial, non-commercial scientific research a more privileged position. Next slide, please. So that was the EU. That's where it's sort of like the framework is probably most developed. And there's actually been so far like one case there's in process in Germany, and you know, it'll focus on what does text and data mining mean under Article 4, but it's also going to focus on what is machine readable for the opt-out. But again, it's at a very early stage. Now, the UK does also have a statutory exception, but it's just for the sole purpose of research for a non-commercial purpose. So it's not as broad as what there is in the EU, and part of that is just because of the timing of Brexit. Because of when Brexit happened. If Brexit had happened later, it would have been a broader exception, but because of when Brexit happened, they have this narrow exception, which just is basically like Article 3, but not Article 4. Ukraine has an even narrower TDM exception. I think part of it might be, you know, they are interested, of course, in joining the EU, and so a lot of their laws are similar to those of the EU. I'm not quite sure why they ended up having something so much simpler. I don't know if it was a translation problem or they just weren't, you know, sort of quite understanding what was going on. But in any event, the Ukraine's TDM exception is narrower in certain respects than the UK, than both the UK but also the EU model on which it's based. Next slide, please. So now we're going to look at some other countries where that have adopted specific exceptions. So Singapore, in typical manner for Singapore, has a very sort of detailed, complicated exception because that's how they draft their laws. And a lot of what's also interesting when you do this kind of sort of comparative international law and you see how these statutes are so different, they're obviously largely a function of the differences in the political system. So in Singapore, you have an agency of the government, and they write the statutes, and then the legislature adopts them, meaning there's not a lot of sort of the fighting and democratic process of different bodies. It's sort of like the government decides, or an agency decides, and that's how it is. Whereas in Europe, of course, it's a much more decentralized process, and so there's many more compromises. In any event, in Singapore, there is you're allowed to do the reproduction for purposes of computational data analysis. And again, it's always important to say, what does that mean? And they do have a definition. Using a computer program to identify, extract, analyze information or data. And using the work as an example of a type of information to improve the functioning of a computer program in relation to that type of information or data. And then they give sort of an example of that. It's like an example of computational analysis under paragraph B is the use of images to train a computer program to recognize images. So it's very clearly envisioning training artificial intelligence. Now, what's interesting about this example is like it's using to train a computer program to recognize images. And so I'm sure at some stage in litigation, someone might argue, it's to recognize images, not generate images. And we'll have to see that. We'll have to sort of see in the future how that plays out. But I think most experts believe that it is, again, this is intended to be extremely broad and would cover ingestion for purposes of training generative AI. Next slide, please. So Japan, in addition to the exemption that Ben mentioned about sort of like non-consumptive purposes, they also have a specific exception for data, for ingestion for data analysis, and then again, meaning the extraction, comparison, classification, and so forth. So it is broad. It doesn't have any. It's not limited just to scientific research. So it's a broad exception. And again, unlike the EU Article 4, but like the Singapore provision, there's no opt-out. I mean, that the opt-out is something that seems so far to be unique to the EU. Next slide, please. Okay, so those are some of the countries that have specific exceptions. And now that's a lot, obviously, all of the EU, UK, Ukraine, Singapore, Japan. Now, as Brent explained, there's this other approach that's been adopted, and that's what we have in the United States and other countries that have a fair use system. And there, you have to rely on precedent. So far, there isn't a precedent directly on point with respect to ingestion for AI purposes, but you have a lot of cases that are similar, okay, where you have the assembly of large databases for AI type functions such as search, plagiarism detection, and those were found to be non-infringing, like all the ingestion under a fair use theory. And with fair use, you have a 4-factor analysis. And again, you're always sort of looking at what the precedents, how earlier cases interpreted those factors and apply them to these new facts. But again, those AI functions in that litigation were much more basic and arguably much had less likely to have a competitive impact than generative AI, or at least an alleged competitive impact. So the key issue in these cases, and there's now over 30 pending cases in the United States, is to what extent do those precedents, like the Google Books case and the HathiTrust case, to what extent do those precedents apply in this new situation? Now, just interestingly, the Israel Ministry of Justice has an opinion letter saying that the copying involved with machine learning, which is sort of this training process, is a fair use. Israel has a fair use provision similar to the United States, and they relied on the U.S. cases and U.S. Jurisprudence to come up with their analysis. But again, that's just one agency's opinion on that issue. Next slide, please. So just in conclusion, it will be very interesting to see what happens in these cases in the United States. Again, there's 30 of them. And so what that means is you're going to get district courts sort of going off in different directions. And also the facts for these different cases are different. It's different companies have been sued, it's in different kinds of works, music, images, text. And what we're going to see is, again, lots of litigation, and you'll have district court cases coming out different ways, and then there will be appellate court cases coming different ways. Ultimately, I'm sure it's going to have to go to the Supreme Court, and it's going to, and there will be a decision, but it could easily be, 5-10 years before we have clarity in the United States as to fair use. And just one last word again about this whole, what's interesting about this comparison of sort of if the fair use approach or the statutory approach, and even the degree of detail in the statutes, the reason in the United States that they have to rely on fair use is it's almost impossible to get any kind of legislation enacted in the United States. So just because of the nature of our legislative process, as opposed to the process in other countries with more of a parliamentary system where the government can enact legislation. In the United States, everything's always split up, so it's much harder to enact legislation. So we have to rely on fair use, which ends up with a slower, somewhat more chaotic process. But there will be an answer at some point. But it could be by then everyone's going to be following the EU opt-out approach under Article 4 for certainly the big companies. That will be the approach, and that will be that will be the prevailing method by which this is all regulated. Thank you very much.
Okay, thank you very much, Jonathan. Thanks for going through all the legislation. And I know that you have to hop off, and I do want to ask you one very quick question that came in on the Q&A, which is related to just what you were talking about, which is one person has asked about Canada's stance on data ingestion infringements, since Canada uses fair dealing rather than fair use. So maybe you could just say a brief word on the Canadian fair dealing, fair use definitions.
Right. So the statute actually in Canada is quite different from the statute in the US, but the courts in Canada have adopted an approach very similar to that of the US courts, and they often rely on that jurisprudence. And so I don't know if any cases have been filed yet in Canada, but I think there's an assumption there will be. But chances are, I mean, because there's so much integration of the economies, that ultimately, as a practical matter, they probably will do something very similar in Canada. They'll interpret and apply the fair dealing provision in a manner similar to the US.
Okay, thank you, Jonathan. So we do have a couple of questions here that I think we can briefly take. Ben, there was one question about the definition of Article 3 in the EU directive relating to the non-commercial research for scientific purposes, and asking whether it covers non-scientific research. So I put into the answer there the definition, which is in recital 12, which says, which is, wait till I see. So I'm just going to go in here. So the definition says the term scientific research within the meaning of the directive should be understood to cover both the natural sciences and human sciences. And then the follow-up question is, what about humanities and the arts?
Yes, so across the directives, when you see the word scientific research, just to from an English language speaker, just ignore the word scientific. It's confusing. It just means arts, humanities. You know, it covers all works, and that's the same across the copyright directive, the CDSM directive. So yeah, ignore the word scientific when you see that.
Okay, thank you. So that's something possibly for policymakers to, that the language in these directives and the legislation should be clear and broader, so as not to look like it's imposing a restriction that maybe not actually exists in practice. Ben, we had another question about policies, model licenses and policies on AI for repositories. Are you aware of?
So yes, I didn't understand that question, whether it was referring to a university being, or a library being, a licensee or a licensor. In terms of a library being a licensee, I put a couple of links to some great stuff that University, Berkeley University, Rachel Sandberg, who I'm actually doing a webinar with on September 27th, Knowledge Rights 21. Check our website, a little infomercial there. So I put a couple of links at some work she's been doing around licensing of content. I'm not aware of any model licenses where universities and libraries are approached for public domain material. I mean, there are public-private partnership licenses, which I'm sure the British Library would be happy to share, but they're not AI specific. You know, they're just sort of for creation of databases, like by people like Cengage and Gale.
Mm-hmm. The other issue I guess we should be aware of is are there national policies on AI and AI strategy, and we should also be keeping an eye on those policies. So there's a policy in South Africa, there's a new policy in Nigeria, for example, and I think it would be important for libraries to engage already at the national level when these national policies are being developed, because then that will help further down the process when those policies are being implemented.
Yes, I think this is sort of my slide about senior leadership. I think it's incumbent on senior leaders in university to engage with this, with machine learning. You know, it's a modern, I mean, it's been around for quite a while now, 60 years, but it's a form of research, and therefore university leaders, library directors need to engage in, how as a university they're going to approach it, how they're going to approach the exceptions, how they're going to approach unfavorable licenses which are seeking to stop machine learning. You know, I really think that there are issues, and as you've said, Teresa, I think that requires government affairs policy work. You know, universities engaging with government to say it isn't all about music and pretty pictures and Mickey Mouse. You know, there are serious applications, very, very important applications of machine learning that relates to science and technology and medicine, et cetera, because I think what we have in Europe at the moment is policy being led by the nose, by the entertainment industry, and that's hugely dangerous for as I keep saying, for research, for science, for medicine. We really need to engage to sort of change the debate and broaden the debate.
Okay, thank you very much, Ben. So I think we're just a couple of minutes over our time, so I think we'll end our session right now. Thank you so much to everybody for attending. Thanks for all the questions. We'll try to put some of the questions together and address them, later on in the materials. And thanks to everyone who put links into the chat as well with examples of national policies and AI and license information and so on. And I think it's all going to help us all as we're all learning and working in this new environment and grappling with all of these issues, and just bearing in mind, as I think the message that Ben said very clearly at the start was, we're looking at this from the perspective of AI for research, for development, and for innovation, and from the library perspective, and that's our goal. And I think we should be clear on that, and and not be distracted necessarily by the other issues that are coming in that are not necessarily related to these very important functions and to the amounts of money that all our governments are investing in research and innovation. So thank you so much. Thanks to our speakers, Jonathan, who has already had to leave for another meeting. Thanks very much to Ben for joining us from Portugal, and we hope to see you again. And thanks to everyone for attending. Thank you.